Oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
Please be seated. Good morning, everyone. We'll now call our first case on the docket this morning, AP-77-106, William George Davis versus State of Texas. We'll hear first from counsel for the appellant. Is it Mr. Rediker? Mr. Schonemann.
Thank you, Mr. Presiding Judge, honorable members of the court. May it please the court, my name is Raoul Schonemann. With my co-counsel Thea Posel at counsel table, I represent the appellant William George Davis. This appeal is on direct review to this court from a capital murder conviction and death sentence out of Smith County, Texas. We have noticed somewhat ambitiously 5 points of error for this argument. I intend to concentrate my argument on points of error number 1 and 2, and to the extent that I have any time remaining, I'll address the remaining points of error. I've reserved 3 minutes of my time for rebuttal. Turning to the first 2 points, the Texas Constitution, the federal Constitution, and Article 3629 of the Code of Criminal Procedure require a unanimous jury verdict of every essential constituent element of a criminal offense in order to convict a defendant of a serious offense. The Supreme Court recently said in Ramos versus Louisiana in 2020 that the unanimity guarantee of the federal Constitution is among the most basic and essential guarantees that the defendant has as a matter of due process in a criminal trial. We submit that that guarantee, the guarantee of a unanimous verdict, was compromised and violated by the jury instructions in this case. Mr. Davis was charged at trial under charged with under an indictment pursuant to Texas Code of Criminal the Texas Penal Code section 19.03A7, which defines a capital murder as the murder of more than one person. In this case, Mr. Davis was...
Doesn't that definition short circuit what the statute actually says? I mean, in other words, it says you have to commit a murder, and then it says more than one person, right? So, I mean, you can't just ignore the statutory structure, right?
Well, this court has already construed this particular subsection in cases that we discuss in our brief, and has construed this particular type of capital murder as unlike any other type of capital murder in Penal Code section 19.03 because the allowable unit of prosecution is 2 murders, at least 2 murders, and that's distinctive to this offense. And this court said that in a case called Ex parte Milner and in a case called Don Anthony Science versus State. So the court distinguished this particular type of capital murder as requiring proof of at least 2 murders. And that distinguishes it from any other type of capital murder in section 19.03, which only requires 1.
If we agreed with you, how would we reconcile your going with you in this case with our opinion in Kitchens that addressed a separate aggravating type of element for this offense?
Kitchens is a case in which this court has said and recognized a very well-established principle as a matter of Texas law and really the federal law as well, which is that juries need not be unanimous as to the specific manner or means by which a criminal offense is committed. That's a very well accepted. We don't contest that principle. So applying that to the capital murder statute in Kitchens, I believe Kitchens was charged with the murder of an individual victim, and there were alternate theories as to how the specific manner or means by which the victim was killed. That is, during the course, in his case, I believe, of a sexual assault and during the course of a robbery. And this court held that those were simply those felony offenses, robbery and sexual assault, were simply the specific manner or means by which that offense was committed. But in a subsequent case called Francis versus State, which is cited in our brief and discussed in the brief, this court said that Kitchens is inapplicable, that's a quote, for a case in which a defendant is not charged with an individual offense, and the question is the alternate method or means or method by which that offense was carried out, but where a defendant is charged with multiple criminal offenses, which is the case here. So
is it a separate criminal offense? Does the statute make it essential what the identity of the other victims are? What if we had, a concentration camp guard who is indicted for for one murder that we can identify? We know many other people were killed. We have video of it, let's say. We don't have names, we don't have the records. You're saying on that fact pattern, the statute would not permit the offense to be aggravated as required?
It would depend, I suppose, on what the specific language was of the aggravating circumstance. Here, the criminal offense is defined as, and the court has held, that in order to convict a defendant of murder of more than one person, the jury must unanimously find the defendant guilty of the predicate offense, which is the first named victim in the indictment, and at least one other murder. So it requires, in other words, proof of 2 murders, unanimously and beyond a reasonable doubt. I don't know if that answers Your Honor's question, but...
It goes halfway there.
Okay.
The identity, you're saying that unanimity requires not an agreement among all 12 jurors that there was, in fact, a second murder committed by the defendant of another separate individual, but they have to agree on the identity. That would require proof of who that other victim was. So if we had somebody, Jeffrey Dahmer, for instance, captured with multiple victims' bodies, if we couldn't identify by name the other bodies, what would we do with that case?
What this court has said is that the murder of one individual is a different offense than the murder of another individual. That doesn't necessarily, to try to answer your question more directly, necessarily mean that we have to be able to identify the victims by name. But we do have, what does have to be proved to the jury's unanimous satisfaction is that the person that was killed is the person that is identified in the indictment. So it's the act that the jury has to find unanimously, and in most cases that's inextricably intertwined with the identity of the victim.
But we don't have, the state doesn't have to allege the name of those other victims in the indictment, do they?
They did in this case,
Okay.
Your Honor.
But is that, in thinking through the problem, right? Because I think probably everybody's gonna be more satisfied if we resolve this in a way that clicks with all the other underlying presumptions, but does the state really have to do that, or are they just doing it because it seems like, well, we know who they are, let's put their names in there?
Well, this court has said, and this is a basic principle of the offense of murder, is that one only proves a particular allegation of murder if one can prove that a particular individual is killed. One doesn't prove, a defendant cannot be convicted of murder of some unidentified person where the jurors were allowed to consider the possibility that what was one of a number of different people and to agree just unanimously that a person was killed, but we don't know which person that was. So I would argue that in this case, the defendant was charged specifically with the commission of 4 knowing and intentional murders. The jury was required under this court's construction of this particular penal code section to conclude that the defendant was responsible for the death of the predicate victim, Mr. Greenaway, and at least one of the other 3 victims. I want to turn to the question of preservation because the defense, and this is to try to address your question, Judge Urey, about how the court should proceed, the defense proffered a written jury instruction to the court that would have held the jury to the state to its burden of proof in this case. Our contention is that that was sufficient to preserve error under 3615 as to the state constitutional challenge in this case. In the jury instruction that was requested, we submitted to the court in bench exhibits that we filed last week, and that is Exhibit 3 of those bench exhibits. And so we submit that that was a proper way of instructing the jury in this case.
It doesn't answer the question that Judge Urey asked you initially about whether it was necessary. Now, in this case, they did include in the indictment the identities of the other victims, and as you said, and I want to take you back to the way you put it, and I thought quite well, of it, a murder of at least one of the other people. Why isn't the answer of yes to that sufficient? At least one. What you're saying is you wanted, per your instruction, which of the other 3? Why is that necessary if the aggravation to elevate this case to capital murder would be satisfied by a yes answer to the question as you posed it? At least one of the other 3.
Because if I understand Your Honor's question correctly, the jury has to unanimously agree as to that a particular offense was committed. That's what the unanimity requirement requires. And ordinarily the way that is done is by alleging that a particular individual was killed, and then the prosecution has to summon sufficient evidence to convince the jury unanimously that that was the person that was killed. I think the hypothetical that you presented to me was, what if other people were killed that we could not identify by name? I think in those circumstances, the state would have to still prove that the defendant was responsible for those particular individuals' deaths, however they were identified in the indictment.
Yeah, but the reason I asked that hypothetical was to test the premise of, do we have to know the identities, or is it enough for the jurors to all agree that at least one other person was killed?
It is not sufficient. That is essentially, it is because a jury does not unanimously find the defendant committed a specific act of murder in that way. They have to the identity of the victim is an essential element of the offense of murder. As this court said in Johnson versus State, the murder of one individual is a different offense from the murder of a different individual. And so the identity of the victim is an essential fact that the jury must find in order to find that there were two offenses of murder, at least two offenses of murder that were committed in this case.
Well, that would be true if he were charged with two separate offenses of murder. But we're talking about one charge of murder plus additional possible victims. You know, maybe more than one, but at least one other.
I would submit to Your Honor that the state's burden of proof should not be less in these circumstances. If the state, for example, had charged in this case 2 counts of murder, non-capital murder, the state would have been required to prove the identity of both the predicate, or to prove unanimously the defendant committed the predicate offense as well as unanimously the non-predicate offense. Here the state has simply added additional named victims to the indictment, and now thinks that it only has to prove unanimously the victim of the predicate offense and gets a discount on its proof as to the non-predicate offense, because the jury was instructed that it need not be unanimous as to which of the 3 non-predicate victims were killed.
But that's because he's only charged with one offense. He's not charged with multiple murders.
But the paradoxical result of that, Your Honor, is that in the scenario that I just sketched out, the defendant would be convicted of 2 counts of non-capital murder and sentenced to a maximum sentence of life imprisonment, whereas in this scenario, by adding the additional victims to the indictment and instructing the jury that they need not be unanimous as to the non-predicate offense, the state manages to obtain a capital murder conviction which carries a greater penalty. And we submit that's not consistent with the idea that the state is shouldering a greater burden of proof when it charges these as separate offenses instead of when they're charged together.
Assume for the sake of argument that the jury had acquitted on the charged offense, right? What would happen, in your view, if they then attempted to bring one of the uncharged offenses in a separate prosecution? Were those cases before the jury in terms of guilt or innocence for that as a separate charge?
I'm not sure, Your Honor, which offenses you're referring to as uncharged
we
offenses.
We have 4 claimed murders. 1 is charged, the other 3 are the aggravating. Okay. If they acquit on the first one and the state then attempts to try any one of the other 4, would you say there's a double jeopardy?
There is a double jeopardy violation, Your Honor. Yes. The unit of prosecution, allowable unit of prosecution in this case was 2 murders, and that consists of the predicate offense and any one of the non-predicate offenses. There would be a double jeopardy bar.
Double jeopardy as to the capital murder or the murder, or just both? If he was acquitted on the capital murder charge?
I would suggest that there would be a double jeopardy bar against the prosecution of another prosecution of any of the victims named in the indictment. It should be borne in mind that this indictment accused Mr. Davis of killing 4 specific individuals, and if the jury returned a verdict acquitting him of that indictment, then double jeopardy would bar any prosecution for any offense related to the other 4 victims. I think it's inappropriate really to refer to them as aggravating offenses, because in this indictment he was charged with multiple offenses of murder. And the jury was...
Isn't the same true when you charge capital murder in the course of a kidnapping or a sexual assault? Aren't you charging other offenses in that situation?
You are.
In the same way, except for that I'm struggling with, I really don't know, as I sit here today, I'm sorry to, disappoint you about my not knowing something, but I'm wondering whether the state really needs to include those names in order to satisfy alleging the elements of the offense in this case.
The distinction, I think, resides in both state law and federal law, federal constitutional law, between the idea of manner or means, which the jury need not be unanimous about when the state alleges that a particular victim was killed, and there are alternate theories or manner or means by which the victim was killed. That is Your Honor is referring to that type of scenario in your question. This court has already said that that branch of case law does not apply when a defendant is charged with, as was this case.
And maybe this is where I might be bringing myself down the trail to questioning whether maybe were we right when we said that?
You were,
I mean,
Your Honor,
it seems to me it's hard to say you're right about that, and you're right also about kitchens, right? What we said in kitchens. They seem to be in conflict, and I do think the court should at some point in time, if we're gonna maintain this dichotomy, have some reasonable explanation for it.
The case in which this court distinguished Kitchens is a case called Francis versus State. It said Kitchens is inapplicable where a defendant is charged not with alternate theories of committing the same offense, but rather with 2 or more separate offenses were submitted to the jury in the disjunctive. That was the fact pattern in this case. This was 4 offenses. They were submitted to the jury in the disjunctive. It makes no sense to really apply the manner or means branch of case law to a case of this type, because murder is not a manner. The murder of, for example, the decedent Joseph Kalina, who died in 2020, can in no meaningful sense be regarded as the manner or means by which another victim was killed 6 months earlier. So that stretches the meaning of the terms manner or method beyond any sort of acceptable use. This court and the Supreme Court has applied or recognized the application of the manner or means branch of case law where the defendant is charged with an individual murder that could be committed in multiple ways, but does not apply that, and that allows the jury to find the manner or means by non-unanimously, but has distinguished that from a situation in which the defendant is charged with multiple instances of a discrete criminal offense, in this case, multiple instances of murder. I see that my time has expired, so I'll reserve the rest for rebuttal. Thank you.
Thank you. We'll now hear from counsel for the state.
May it please the court? One thing I noticed at the charge conference, I know the court has before it, as one of the bench exhibits, Mr. Parks, one of his trial counsel, acknowledged before Judge Jackson that in making that request for a unanimous finding on each of the non-predicate murders, that the law was not on his side. And I took notice of that. I think that was candid, and I think that was right. But this doesn't appear to be an area of the law, and that is unanimity with respect to 1903 and the aggravating circumstances, where this court has only lifted up a little bit of the curtain every time the issue's been raised. It seems like in Kitchens in 1991, the court just whipped up that curtain in saying that, and this is in 1991, so it's 5 or 6 years after A7 was added to Section 1903, where it said that alternate theories within the same subsection alleged in the conjunctive and charged in the disjunctive, a general verdict of guilty to capital murder would be sufficient, and the jury was not required to elect between the different aggravated circumstances within the same subsection. In that case, it was A2, robbery and aggravated sexual assault, and it cited Shad in its opinion. And so Kitchen's progeny, all the way up through the Kimberly Sciences case in 2014, has relied on that principle and then extended it out to subsections within different, or extended it out to aggravating circumstances alleged from different subsections within 1903. But almost 15 years after Kitchens in Martinez, another robbery and aggravated sexual assault case, the court said unanimity requirement not violated by instructing the jury on alternate theories of the same offense. And in contrast to a situation where there's two separate offenses involving two separate incidents. So to answer that question about whether it's different offenses, I believe the court in developing through Kitchen's progeny makes that determination that it is a single offense of capital murder. So for example, in Sands, which is one of the first cases under A7, I think. So that was the drug deal gone bad. The appellant murdered 3 people, and the state alleged each of the 3 victims as a predicate murder in separate counts with aggravated by the other 2. And the court said that the addition, at least one murder then, in addition to the predicate murder, is the aggravating circumstance required by A7A. And so we only allow a single capital murder prosecution in that circumstance because the allowable unit of prosecution is more than one murder.
Do you agree with Mr. Schonemann that because the state decided to include the names of these other potential victims, that would present a jeopardy bar if, for example, there was an acquittal for the offense charged in this case, but no lesser included offense instructions given? And so the jury could, under your theory, just choose, which one to believe and which one not to believe. Would that present a jeopardy bar to indicting the defendant and prosecuting him again for one of those individual murders that were alleged as arguably aggravating elements to this capital murder? Potential aggravating elements to this capital murder.
Right. Yes, Your Honor, that's a tough one. I hadn't considered that before. One of the cases I remember in researching this thing, I remembered that if it's one offense for unanimity purposes, then it's one offense for double jeopardy purposes, which seem to indicate that it would be barred for all of the victims alleged in this capital murder, this single alleged offense of capital murder.
It makes me wonder then, why would the state ever, in charging a capital murder, allege multiple possible other murder victims when trying a capital case, rather than just naming one, right? In that way, if they were to lose, right, if they're going to get an acquittal, they might, if they have multiple victims, they could go and at least allege one of those other victims and still bring a prosecution against that person for one of those other victims. You see what I'm saying?
Right.
It kind of, it makes me wonder. I like the system to all work as well as possible, and all of these questions are making me question a lot of the underlying premises.
Right.
And so if
You're not alone.
there you go.
But let me ask you this. There are multiple, we're not going to get an answer, I think, today on the double jeopardy question, but there are multiple veins of double jeopardy. There's what you would call classic res judicata, the charged offense, the elements of the charged offense. There's collateral estoppel, the way the case was tried, the facts the jury necessarily determined. But if I understand opposing counsel's argument, and I'll ask him more about this on his rebuttal, it's almost like this becomes a class action murder case, right? Because Texas, in order to get around the Gregg and Furman problem, had a narrow application of this penalty to circumstances that were not arbitrary. So what we did is we had 5 circumstances, I believe, where you could be eligible for the death penalty, and their argument is to granulate the proof of one of the aggravating factors. And what we're struggling with, and we're looking for help with you here on, is what is the necessary determination that jurors are making in determining that this defendant was eligible for the death penalty? Was it that there was another murder, or that it was a particular murder? What's your answer to that?
I think that one thing I noticed in the second science opinion, Kimberly science opinion, which was the injection of IV, or the injection of bleach into IVs. So in that case, the court reaffirmed that the gravamen is, for all capital murder, is knowingly or intentionally causing a death and any one of those additional aggravating circumstances. And so what the jury has to be unanimous about is the commission of that predicate murder. And the additional murders would be, whether you call them aggravating circumstances or different theories would be the same offense. So they do have to be unanimous about the predicate victim. That's required. That's what was missing in science and what the court held, why there was error in that case. And I think it took great pains to identify that that was the error rather than the identities of those non-predicate murder victims.
Counsel, let me ask you a question. If the trial court erred by failing to give the lesser included instruction with respect to manslaughter or criminally negligent homicide, address the harm analysis.
Yes, Your Honor. So the court could see court could see in my brief that I used the same harm analysis that the court used, the fourth court used on remand in the second science case.
Bridges and Bignall?
Well, first, whether there was some error, and actually in the remand of science, it was egregious error because he had not objected to it. And so, let's see.
Would you agree this court's not bound by Bridges with respect to, we're not bound to say harm exists based on the penalty for the charged offense exceeding the penalty for the lesser included? We're not bound by that.
By Bridges, I'm not sure that I cited Bridges in the error analysis in that case, in this case. I just assessed it under the four factors: the entire jury charge, the state of the evidence, the jury arguments, and any other relevant.
How would you apply those factors in this case for the harm analysis?
So the entire jury charge, the error, the alleged error is that one part and no other part of the jury charge. So same thing as in science. The state of the evidence was just as strong as in science, right? There, the fourth court pointed out that there was the idea that they would convict, or the evidence was so strong that they could find that any one of the victims would have been the predicate murder victim, and that's what we have here as well. The jury argument, only that one portion that argued that portion of the charge. The prosecutor did say, you must be unanimous as the predicate murder victim, that's Christopher Greenway, and you must be unanimous that he murdered more than one person besides that predicate murder victim. So either Christopher Greenway and Joseph Kalina, Christopher Greenway and Ronald Clark, or Christopher Greenway and or John Lafferty, rather. And so I mean, that more than one murder, the allowable unit of prosecution, the prosecutor did argue that the jury had to be unanimous about that. And then any other relevant information. So in this circumstance, I know that the analysis was egregious harm there, but in this case, based on the strength of the evidence, I think that in terms of establishing actual rather than theoretical harm, I still don't think that it meets that bar, which is why I thought the error would be harmless if the court found that it had to be unanimous as to each of the named non-predicate murders. But one thing I wanted to point out to the court, I know that in his brief, and I think it was in his reply brief, he mentioned, you know, there's never been another case where it's been interpreted that an allegation under A7 that the jury doesn't have to be unanimous about the different non-predicate murders. And I'm not necessarily sure that that's true. I think that in Gamboa, which was a prosecution where there was an allegation under A2, robbery, and another murder in the same transaction under A7, the court held that the jury was not required to elect between those two. So even though in that situation we still had the additional murder, it wasn't considered something that the jury had to be unanimous about because it was just another aggravating factor or a different theory of the single charged offense of capital murder. So with Gamboa and the second Science case, Kimberly Science case taken together, I believe that his first 2 points of error should be overruled. Now, Dave,
Counsel, I'm sorry. I had a question. It seems like to me that if you look at the plain wording of the statute, it's pretty clear that the other murders are not part of the element of the offense as far as the predicate murder. That's my understanding. How would you address that? So you've got this predicate murder and then these other murders that are combined that have to, you don't have to have you only have to have agreement that not that each murder was committed, but it was in the way it reads the same scheme or course of conduct. To me, that's the issue, and that really goes to the heart of the matter is, were these other murders committed in the same scheme or course of conduct?
yes, Your Honor.
Is that right?
I believe that is right. And I think that, yes, that's really the argument that I was trying to make in a nutshell, yes. And so, now, while I think Gamboa and the second Science case are dispositive, one case I did notice, and I cited it, was Davis, and I think it was the holding in that case. That was a burglary habitation case, 2 different victims for the burglary of habitation, and the appellant was asking the court to require that, or that the jury should have had to be unanimous about which of those 2 burglaries the defendant had committed under A2 of 1903. And so the court said it's still on capital murder based on the murder of that predicate victim. Nothing prohibits a single capital murder from containing alternate underlying theories that are the same statutory offense. So same statutory offense of murder, for example, but with different victims, like we have in this case, different underlying.
It's clear that the additional murders elevate the offense to a capital.
Right.
Standing alone, the first murder is simply a murder unless there's some other aggravating factors. The aggravating factors here are the additional murders. So you've got 12 jurors, 3 separate victims beyond the predicate murder. If you have 4 jurors that agree that Lafferty was killed by the defendant, 4 more agree it was Clark, 4 more agree it was Kalina, your position is that that's sufficient to convict him of capital murder.
Your Honor, did you say that they had to be unanimous as the predicate murder victim?
Well, yeah, they would have to be unanimous as to the predicate, but then you have 3 victims and you have 12 jurors, so let's just say the jurors are split 4, 4, and 4 on who commit, on each of the individual murders after the predicate murder.
Right.
Your position is that is sufficient to establish a capital murder conviction. They're not unanimous. There's just 4 separate jurors, 4 groups of jurors, 1, 2, and 3, that agree. First 4 say it's Lafferty, second 4 say it's Clark, the third 4 say it's Kalina. Your position is that is sufficient to sustain the capital murder conviction, correct?
I believe.
And I'm not sure how the defense wants to go about that, because I haven't heard anything about special issues on how they would arrive at that. But your position is that the jurors do not have to be unanimous as to the additional killings.
As to, well, which of the,
Right,
which of the.
that's correct.
Yes, Your Honor. And I think, right. And so, well, because they were required to be unanimous, he killed at
We're
least
required to
one.
be unanimous. All 12 had to agree that at least the defendant committed one of the 3 murders, right?
Right, at least one of the additional murders.
So there's no real unanimity as to the second prong of this capital murder.
Well, I thought the charge did require that he murdered at least one person in addition to the predicate murder, pursuant to, not during different transactions, but pursuant to the same scheme or course of conduct. So I do think that it was required to find that more than one, that piece of it, the jury was required to be unanimous about.
Counsel, isn't that really the crux of the issue? The gravamen of this offense is causing the death of more than one pursuant to the same course of conduct. That's this offense, capital murder, causing the death of more than one, right? That's the gravamen of this offense. As to that, the jury must be unanimous. And we've previously ruled in Sands and the other one that there must be unanimity as to the predicate murder and unanimity as to causing the death of more than one. But we have never before required unanimity as to which of the second or third or fourth was caused, right? So the gravamen here is cause the death of more than one during the same course of conduct. Is that correct?
Well, I'm not so sure that's correct, Your Honor, because I know that in Kimberly Science case, the court sort of reaffirmed that the gravamen of this capital murder is still causing the knowing or intentionally causing a death and any one of the additional aggravating factors, even in a case alleged under A7B. So.
A7B is literally more than one.
Right.
Well, that's the aggravating circumstance. The actual offense charged is the capital murder of the predicate victim.
Yes.
Is
Yes,
it
Your Honor.
not?
Yes, Your Honor.
Counsel, I see your time's about to expire. Before you go, I don't see it raised by the briefing, but being this is my first death capital murder, I wonder if you could help me with this. To get to where we are now, post-Greg, in Texas, we have our system here of qualifying what I would call aggravating activities, which may or may not require unanimity or whatever else. But there's another prong here, and it was addressed in Greg, and I think this court has flirted with it, of the potential for arbitrary application of this penalty, given that we have 254 counties, 254 district attorneys, all of whom are exercising their own discretion that could be always or never to pursue this penalty. And who, if anyone, is overseeing that to make sure that we don't have what Justice White considered the strike of lightning, arbitrarily coming in some circumstances or some cases and not others. We've had a lot of difficulty recently with district attorneys. Is it potentially a problem that we have effectively different law for capital punishment, county to county, without that oversight?
I don't remember researching that at all, Your Honor, but
If you know, that's fine.
Right.
I'm not saying it's even raised here. I'm just wondering if you could help me understand it.
without reading Greg and getting myself situated, I don't think I can answer that as to discretion and abuse of discretion for prosecutors.
Okay, if you want to take a couple of minutes and sum up, sorry, I've taken you afield.
But with Davis and Science and Gambo, we're going over those with you today. I think the court understands that our position, and I hope I made it clear in the briefing, but that our position is just that this is a straightforward application of Kitchens and its progeny. And and there's nothing about, Ramos or any of those more recent Supreme Court opinions that changes that in this case. And so with that, thank you, Your Honors.
Thank you very much. We'll now hear 3 minutes, I think, for both.
So at the outset, I want to emphasize something, which is about the fact that there is no authority in Texas law, neither this court nor any court of appeals has ever written an opinion saying that a non-unanimity instruction, as was given in this case, was approved by the court. When unanimity issues have arisen, unanimity challenges have arisen in cases, it's been because the charge omitted what appellant felt was a necessary unanimity instruction. In other words, the charge was considered deficient because it did not sufficiently instruct the jury about the requirement of unanimity. Here, we have a greater problem. It's not just that the charge was deficient, it's that the jury was affirmatively instructed that they need not return what we view as a unanimous verdict. So that's the first thing. There is no authority supporting this instruction. In fact, we have reviewed jury charges in 19.03A7 prosecutions. This court has those jury charges on its website. We have yet to find any other capital prosecution brought pursuant to this penal code section in which a jury has been similarly charged. So that's the first thing.
But is it your position that there just needs to be special issues as to each of the victims beyond the predicate offense alleged in the indictment? And so the jury has to unanimously find any one of those? They have to be listed in the jury charge?
Yes.
Is that your
And
position?
our position is that the defendant in this case proffered a written instruction to the jury about how they could decide this case in such a way as to properly convict the defendant of multiple murder in this case. And I would suggest that jury instruction would be an appropriate jury instruction. The only thing I would add is that it should emphasize the jury needed to find each offense unanimously.
Counsel, let me ask you a question. So in fraud cases and in continuous sexual abuse of children cases, basically the state could just say, from this day to this day, these bad things happen. There's no requirement that the jury be unanimous. So are you kind of saying here that this is a special case because it's a death penalty case?
Not because it's a death penalty case, but depending on how a particular criminal offense is defined and the acts that would satisfy it, I think that may be the answer to your question, Your Honor. So I know that in this, murder is specific to the individual. That is the unit of prosecution. Other types of offenses are defined in terms of a unit of prosecution where the prosecution has the burden of proving perhaps multiple instances of a particular act. So the reason why this analysis applies to capital murder is because the court recognizes that each murder of a particular individual is a discrete offense. Judge Ear, you asked opposing counsel, why would the state ever allege more than one additional murder? And I think the answer to that is because of the windfall that they got in this case. They alleged 4 offenses and then sought an instruction to the jury that they need not be unanimous as to the second victim. That allowed the jury, and they were encouraged explicitly by the prosecution in closing argument, and were told that if only 4 of them believed that Mr. Davis killed Mr. Lafferty, 4 others believed he killed Mr. Clark, and 4 others believed he killed Mr. Cullena, that was a unanimous verdict. So the state was empowered by this non-unanimity instruction to obtain the conviction in this case. Had they only alleged 2, they would have had the burden to prove both offenses were committed by Mr. Davis unanimously. And that's why I'm saying that this is an inconsistent result when it would be inconsistent for the court to allow the jury to be charged in this manner. The opposing counsel said, and I think this was in response to a question from Judge Finley about the Kimberly Science case and what opposing counsel said is that I think that Judge Finley, I'm trying to recall your question, but I think you were saying the court has never required the jury returned a unanimous verdict as to the non-predicate offense, if I understood your question. The Science case, I think, is an appropriate case for the court to look at, because in that case, first of all, this court reversed the conviction in Science for a unanimity violation. The court observed in that case that the jury charge didn't specify the killing of a specific predicate victim, but it also observed that the jury charge did not require the jury to specify which two or more of the 5 alleged victims that they agreed the appellant had murdered. So there were 2 problems that had been identified in the jury charge. The court reversed because of the deficiency as to the predicate offense, because that was all that was necessary to say that that particular charge was inappropriate, but didn't have to reach the question I think that you're asking. But the court did observe that the charge was problematic in that respect. So I would argue that Science is an instructive case. It doesn't resolve the question that you posed to opposing counsel.
I do have just one final question, and this is, I'm going to try to turn the facts on their heads a little bit here, but if we had this same indictment and the jury decided to acquit of, and let's say we had all the alternates were listed as potential lesser included offenses, right? And the jury were to have acquitted for the murder, they might have found that he didn't commit the preliminary murder, right? But they found that he committed all these other ones in the same course of conduct. Would he be guilty of capital murder, or would he only be guilty of the multiple murders?
In order to be found guilty under Penal Code 19.03A7, this court has said that the jury must return a unanimous verdict finding the defendant guilty of the predicate offense. So in that situation, your hypothetical where the jury finds that he did not commit the predicate offense but committed the non-predicate offenses, he would be guilty of non-capital murder.
So doesn't that counsel in favor of understanding that first predicate offense as something very much different in the analysis than just multiple murders where you killed a lot of people? Because that was, you started off your argument today saying capital murder under A7 is killing of multiple people. And if the jury returns a verdict that says he did kill multiple people, according to the same, course of conduct, et cetera, he's guilty of capital murder. So it strikes me as odd that you would say that he wouldn't be guilty of capital murder if the jury found that he committed all these multiple murders, but yet he has to be, you answered, I think you know what I'm asking.
I think it's a consequence of the jurisprudence of this court already, which has required, in order for the defendant to be convicted under this penal code section, that there be a unanimous verdict of guilt of the predicate offense as well as at least one other offense. And that's the reason why the predicate offense has that specific significance. I wanted to also address, and we do this in our brief, that there's a lot of discussion about these non-predicate offenses as aggravating factors. And the Supreme Court has said basically that the unanimity requirement, the right to a jury verdict as to aggravating factors, the right to a jury determination of any fact, whether it establishes the defendant's guilt or eligibility for a greater range of punishment, is subject to the Sixth Amendment requirements of unanimity and proof beyond a reasonable doubt. So it doesn't matter whether we regard the particular fact as an aggravating factor or an element of the offense, the Sixth Amendment requirements apply to that. And so we would submit that whether the court thinks...
Can you remind me the name of that case?
Ring versus Arizona, Your Honor.
Thank you, counsel. If you have about 30 seconds more, if there's something you think we need to hear, I'd appreciate it.
Sure. The state has conceded in this case, or acknowledged, that that our challenge under federal constitutional grounds to the non-unanimity instruction is preserved. The burden is on the state, if in fact the instruction was erroneous, to show that it was harmless beyond a reasonable doubt. That imposes, that's the highest standard of harm, the highest standard of harm that is imposed on the state in any case. And so in order to satisfy that burden in this case, the state would have to exclude any possibility that the jury could have reasonably convicted the defendant relying on an instruction that the the prosecution requested and then argued to the jury in urging them to convict the defendant. We submit that the state cannot satisfy that burden of showing harmlessness beyond a reasonable doubt when they requested the instruction, argued the instruction to the jury, and re-indicted this case to reposition Mr. Greenaway as the predicate offense. Everything that the state did in this case indicates that the state was attempting to seize upon the non-unanimity instruction in order to obtain a capital murder conviction in this case. The state cannot satisfy its burden of showing harmlessness beyond a reasonable doubt. We would ask the court to reverse the conviction in this case.
Thank you so much. And before you both leave, I want to commend you for the excellent briefs. I've rarely seen better briefing in any case. I've read thousands. I think it's been a well-presented case by both sides. I want to appreciate you, express my appreciation for the work you both put in. It's obvious. Thanks very much.
Thank you, Your Honor.
The court will now stand in recess for about 10 minutes.
All rise.